the next source. So you have your primary source, the Constitution itself, the plain text of the Constitution. You also have the entire structure of the Constitution. So impeachment is referenced in other parts of the Constitution that further inform its meaning and understanding. And a look at that would also continue to support and substantiate the basis that a impeachable offense must be an indictable offense. In the words of various founding fathers who have argued this precise issue on the Senate floor, it's only impeachable if it's indictable. That simple principle, that simple precept, animated the Constitution's language and structure. But if we go past that and we go to the next stage, we go to secondary sources of information, secondary sources of persuasive reasoning as to the meaning and interpretation of impeachable offenses, we find it in the very first infamous impeachment trial, the first high-profile impeachment trial, the first impeachment trial of a high officer that was held very close to the founding of the country, the impeachment of Justice Samuel A. Chase in 1805. Of note, there was a journal kept, it's called Hines Precedents, that you can find online, that details the arguments made in that impeachment trial. Here's an excellent opportunity for us to historically understand the meaning of impeachment beyond what the plain language of the text says. What did people argue around the time when there was an actual impeachment trial on the Senate floor to the meaning of impeachable offenses? And we have on the Senate floor at that point arguing a Supreme Court Justice, Samuel Chase, arguing on his own behalf, an active judge, Hopkinson, arguing on behalf of Justice Chase, founding father Luther Martin, one of the people who was at the Constitutional Convention, participating in those debates, also on the Senate floor, arguing about the meaning of impeachment. And beyond that, and what constitutes an impeachable offense. And beyond that, we have future Senator and learned counselor Robert Harper. We add that quartet of counsel together, and we get a very good understanding of what the Founding Fathers meant by high crimes and misdemeanors, by the arguments made on the Senate floor, the counter-arguments made on the Senate floor, and how the Senate voted. You start off with the fact that they considered it a foregone conclusion that the Senate would convict Justice Chase because there was a two-thirds political opposition to him in the Senate. On top of that, despite that fact, the Senate acquitted. And in fact, a majority of the Senate voted with him on almost all of the counts and charges. How did that happen? That happened because of the arguments being made by Judge Hopkinson, being made by Luther Martin, being made by future Senator Robert Harper, being made by Justice Chase himself. And their principle was a simple one. If it's not indictable, it's not impeachable. That's what the meaning of impeachable offenses is. That's what the plain language of the text is. That's what the purpose and policies behind it is. That's what the entire structure of the Constitution supports. And that's what history would say it needed to be in order to protect the young republic, to protect the separation of powers, to protect the democratic check on government. And that was their argument. And their argument was consistent all the way through. They explained that any other argument would negate the plain language of the text, that any other argument would undermine the separation of powers, that any other argument would make the Congress above the Constitution and the superior branch, not a separate branch of power. Ultimately, their arguments were so persuasive that they had senators who had opposed Justice Chase, who came into the trial anticipating voting guilty, reversing their vote on matters of constitutional principle.